Good evening. Welcome to today's Tax Talk. I'm your host. I'm attorney Stephen Leahy. Today we're going to talk about student loan debt forgiveness and bankruptcy. It's everybody knows you can't discharge student loans in bankruptcy, or can you? Let's find out. Let us start the show. Well, welcome to today's show. It's Thursday, August 5th, I believe. It says it right there on the, what's it say on there? I think it's August 5th. Yeah, it's all Thursday, August 5th. I've been meaning to get to these stories about student loans because I help people with bankruptcy. I have a very good friend, attorney Ray Kaplan, who helps people with federal student loans. Everybody's known that you can't discharge student loans in bankruptcy. It's one of the, whenever I talk to somebody about bankruptcy, there's debts that aren't dischargeable, recent taxes aren't dischargeable, child support payments aren't dischargeable, and student loans aren't dischargeable. It's been a staple. Generally, there were student loans that were dischargeable. I had one. I think I've gotten several discharged in the time that I've been helping people with bankruptcy. One was her spouse had forged her signature. And so we proved that the signature was forged and that she didn't owe that money. It wasn't her debt. And we got out of that one. Another one was hardship. But in order to get rid of this bankruptcy, to get rid of a student loan in bankruptcy, we had to prove undue hardship. And the undue hardship has to be undue hardship. I mean, you had to show that you could never pay them. You were never going to go back to work. You were never going to make any money. You were an invalid. You're old, and you're never going to work again. Never going to have another job. Then they would discharge your student loans. But outside of that, they were discharged. They were not dischargeable, and they would always come after you, and you get stuck with it. So recently, you may be aware that we are on a moratorium now for student loans, and they haven't been able to collect on student loans or even charge interest on student loans. Now, I believe that's only federal loans. Might be all loans. I don't know. I'm not sure about that, but here's a graph here about student loan debt in America. It's steadily going. It's through the roof, and it's going higher every day. And it costs more every year to go to college. And one of the reasons why it's more, in my opinion, again, is supply and demand. You give people a lot of money to go to college, and a lot of people go to college, and the numbers, they charge more. And because there's lots of money available for them to charge. But people get in trouble because they don't think about what it's going to cost them later to pay for this student loan. Seems great when you're going to school to just get loans and be able to get an apartment and live like you're back home instead of eating ramen noodles every night, right? They offer these loans and people take them. And so many people are facing hundreds of thousands of dollars in student loans, and then they have some financial issues and they can't get rid of them. But that's still very recently. And as I mentioned, I've been wanting to talk about this for some time because there's been a lot of progress on this, and that there's some of the circuit courts have decided, some taxes are dischargeable. And so let me go through this and we could talk a little bit about this. The domino effect. And what's going on with the domino effect is one court in, I believe it was the 10th Circuit, decided in last September that in fact, not only were they dischargeable now, but that this court found this was an older case, And after the person got out of bankruptcy, their student loan company was still collecting from them. And so then they reopened their case and brought them in front of the judge and said, Judge, they're breaking your rules. The discharge order that was signed by the judge, and said they're breaking your discharge order because they're collecting on this debt that's been discharged in bankruptcy. And again, that's been one of the ways that attorneys would approach this, and they bring in front of a judge. But almost invariably, the judge would say, no, they're not dischargeable, and so there hasn't been a violation of the discharge order. This is generally contempt of court because they're not following the discharge order. So student borrowers, this is where it begins now. Student borrowers with certain types of private loans inch closer to being able to discharge that debt in bankruptcy after a New York court ruling. Okay, so I thought it was a 10th, but on Thursday, the U.S. Court of Appeals for the Second Circuit sided with student debtor against student debt giant, which had argued that the private student loans would not be erased under existing bankruptcy laws. A 3-judge panel determined that certain private student loans can be discharged in certain cases through bankruptcy, just like credit cards and other debts, if certain conditions are met. I don't want to get into the code, Section 523 of the code, but this is the code that the section of the bankruptcy code that said that certain student loans were not dischargeable, and so that's what they always hang their hat on. Well, see, it's in the code; you can't discharge it. So the ruling, along with the similar rulings in the 5th and the 10th, so I did get that right in that there was a ruling in the 10th Circuit first before this. Now there's 3 circuits that are saying, yes, these might be dischargeable. Suggest that private loan servicers such as this Navint, which was from Sallie Mae, will struggle to claim that all private student loans are non-dischargeable in bankruptcy. Of course they're going to take that position. They've been taking that position for years. It sort of creates this domino effect where you've got 3 court of appeals cases saying that this is the type of student loan that can be discharged. You got to give attorneys thinking more about this and really rethinking this categorical advice that they give to everyone that they can't be discharged. A spokesman for the student loan company, which was spun off of Sallie Mae, told us that the latest ruling only applies to one issue in the appeal, and that the company asserted multiple defenses and looks forward to presenting those defenses as the case proceeds. So they're still saying, no, that's only in this case. In other cases, not dischargeable. This is a unique case. This is wrong. Okay, so we go to the next one. Discharged student loans in bankruptcy. Courts agree, but reform could be coming. So again, these courts, 3 courts of appeal have said, hey, maybe they are dischargeable. We're going to find some of them at least are dischargeable. Used to be kind of a blanket. No, none of them are dischargeable. Then these 3 circuits start saying, hey, maybe some of them are. And so now attorneys will have some. Now I remember my own. There's a judge here in Northern District of Illinois who's always encouraged to bring the case before me. There'll be some case that will show that they are dischargeable. At least that's what he encouraged people to do. So now you have some precedent and you have some case law to say, hey, look, Judge, in the 10th Circuit, in the 5th Circuit, they have said that this is discharged. You should find the same way. And you can convince a judge with that. So now they're going that way. But so what is as the district courts? I don't want to leave that picture up there. As the district courts or even the circuit courts, the appeals courts start going that way, right? Start saying, hey, these are dischargeable, and people are going to get some relief, at least from the private student loans. Now the Senate is starting to do something. So they're saying, hey, I think that the courts could do it, but it would make sense to let the Congress come in and make the rules. Okay, so as we said, there's a moratorium until at least September before you have to start paying your student loans again. A new ruling by the U.S. Court of Appeals for the 10th Circuit. This is just a case from what I was just talking about, and the 10th Circuit that they decided. Again, I I get giddy about stuff like this. I can read the court case and I'd like to share it with you. But most people aren't as excited about the court ruling as I get. Okay, so I'm not gonna trouble you with that. Okay, so what's the next case I have? Watch experts testify before Senate on student loan bankruptcy report. So again, it starts with the courts. Courts start saying, hey, these are dischargeable. Maybe some of them are. Maybe more of them should be. And then the Senate starts having these hearings and they're taking testimony about student loans. According to what I've read, it's a bipartisan committee that is trying to change the laws. The Senate Judiciary Committee has held hearing Tuesday on student loan reform. Watch the hearing. I don't want to watch the hearing. Federal student loan payments have been paused since March of last year when the coronavirus pandemic brought the U.S. economy to a halt. The moratorium is set to end October 1st, 2021, unless Biden administration takes further action. We saw that sometimes with the evictions now that they've took unilateral action. I think that's beyond their authority, but they have taken action to extend the eviction moratorium. Could they do that here? I guess they could do that. They could do anything they want as long as nobody stands in the way and says it's wrong. 43% of Americans who attend college, representing 30% of adults, have incurred at least some debt for their education. Rightfully so. Education's not free, but when you're having financial issues, one of the things sometimes, and I've had a lot of clients that their biggest problem is their student loan debt. And so you can get rid of all the other debt, but if you don't get rid of the student loan debt, they're not going to get any relief. There's a story here about someone who filed Chapter 13. Now remember, Chapter 13 is the repayment plan where you repay, and they paid $30,000 to their student loan in student loan principal, but when they got out, they had accumulated about $50,000 in interest. So then when they went into bankruptcy, they were paying $1,000 a month. When they came out, they were paying $2,000 a month. So it really didn't help them, right? It became more onerous. And I just want to finish our discussion here with this story here about the Consumer Bankruptcy Association cautioned members of the U.S. Senate not to change the bankruptcy treatment for student loans. I wonder why that is. Why would they be against it? In a letter to the leaders of the Senate Judiciary Committee, the president said proposed changes that would treat privately issued student loan debt the same as other types of private debt in bankruptcy in the bankruptcy court failed to address the root cause of the student lending crisis in America: unrestrained federal lending without clear disclosure or consideration for borrowers' ability to repay. Well, that's true. These student loans, because they're not dischargeable or have not been dischargeable historically, so they don't really look at your credit worthiness. And so there's people that are going to college, over 18. They offer them the lifeline without them really realizing what that means to them down the road. And, that might mean that I'm not going to get a new car when I get a job. That might mean I'm not going to be able to buy a home when I get married because I've got to pay the student loan. And oftentimes these student loans are 30-year they're 30-year loans. And many times they're at high interest rates. Why? Because people sign these agreements not really understanding what the implications are. And again, when you've got a young person in college and they're eating ramen noodles and someone says, hey, sign right here and you don't have to eat ramen noodles. And you can buy yourself a car and you can have an apartment and you can do all of this while you're going to college. Well, it's a very attractive alternative. And obviously many took them up on them. And that's why we find ourselves in the trouble that we find ourselves with this debt that you see in this chart. I mean, it's mind-boggling, the numbers. Should student loan debt be dischargeable in bankruptcy? The answer is probably. Like every other debt, people need relief. And but I think, again, a lot of this debt was given under false pretenses then, that the lenders believed that it was never going to be dischargeable. And so then they gave it to people that they probably wouldn't have given it to otherwise. Well, loans should be given on a credit-worthy basis, in my opinion. And so maybe if we make them dischargeable, it will rein back this what's going on. They just shovel money out to people without worry about getting repaid, because they know that they're going to get repaid one way or another. And so maybe that'll help bring down this debt if they stop shoveling it out to everybody. And maybe some people have to kind of struggle through college, and maybe that's a good thing. Well, we'll find out. But I again, in my line of work where I help people who have financial problems, having another way to help them through discharging student loans would be, I've seen many cases it would change their life. And of course, that's what bankruptcy is for, a fresh start. And I saw that the name of the new this bill that they're proposing in the Senate is a Fresh Start Bankruptcy Discharge Bill. But bankruptcy is already supposed to be a fresh start. Okay, they're just trying to include it. Now, that doesn't mean that federal student loans are going to be dischargeable. They're still going to protect federal student loans. But as my friend Ray Kaplan, the attorney Ray Kaplan, would tell you, that the federal government has repayment plans that you can work through, even when you're having financial problems. A lot of these private student loans companies didn't have that, and so now there's a different way to address it. A lot like the IRS, and if you owe the IRS some money and it's not going to be dischargeable in bankruptcy, if I can get out and show a hardship to the IRS, they'll leave me alone for a time, maybe forever. Okay, because there's programs in place to help people with taxes, and there's a legislation in place and rules in place to help people with federal student loans. So again, I hope that you found this interesting. If you found it interesting, right, I'm going to ask you then. I'm going to ask you, like, subscribe, share. It'll be very helpful for us if you do that. If you found it interesting, how many people you know that have student loans probably want to know this information, right? I know a lot of people. I need a new microphone. Anyway, like, subscribe, share. I appreciate that. And remember now, if you're having IRS problems, go get my book, Deal with Your IRS Problem Today. Again, deal with your IRS problem today. Go to freeirsbook.com. I'll give you a free copy. I'm going to ask you to pay a small amount in shipping and handling, but I'm going to give you the book for free. I'm also going to throw in several reports, like the 6 things you should do if you owe the IRS money, or the 4 things you should know if you have unfiled tax returns, or the 3 things you should never say to the IRS, and more. There's more in there too. So if you're interested, I'd appreciate it. Go to freeirsbook.com. Again, freeirsbook.com, and we'll be able to get you a copy. So thanks so much, and I look forward to talking to you again next Monday. Now, don't forget, tomorrow is watchtalkradio.com, where you can watch us record our radio show on Watch Talk Radio and on Facebook. So thanks so much. Look forward to talking to you again.